Hello, and welcome back to PEP, your weekly dose of the basics of law, simplified for the common man. If you're new here, make sure to subscribe and hit the notification bell to stay updated on legal insights that impact your everyday life. Each week, we take complex legal concepts and break them down so that you can easily understand your rights, responsibilities, and how the law can protect you. In today's episode, we're diving into a very important and sensitive topic. We'll discuss what constitutes workplace harassment, the protections Indian law provides, and the significance of the #MeToo movement in bringing these issues to light. So, let's get started. Workplace sexual harassment is any unwelcome behavior of a sexual nature that creates an intimidating, hostile, or humiliating work environment for the victim. It can take many forms, from verbal remarks to physical advances and even the abuse of power. The law in India recognizes two types of sexual harassment at the workplace. 1. Quid pro quo. This is when someone in a position of power demands sexual favors in return for job benefits like promotions or salary hikes. 2. Hostile work environment. This occurs when the workplace becomes intimidating or offensive due to unwelcome sexual conduct, making it difficult for the victim to perform their job. In India, the Sexual Harassment of Women at Workplace, Prevention, Prohibition, and Redressal Act 2013, also known as the POSH Act, governs this area of law. Let me walk you through some of the key provisions under this act. Section 2N defines sexual harassment broadly to include both direct and indirect forms of unwelcome sexual behavior. Section 3.2 makes it mandatory for employers to ensure that their workplace is free from sexual harassment and discrimination. They must take all reasonable steps to prevent harassment and take immediate action if it occurs. Section 4 mandates every organization with 10 or more employees to establish an ICC to address grievances related to sexual harassment. Section 9 allows the victim to file a written complaint to the ICC within 3 months of the incident. This time frame can be extended by another 3 months if sufficient cause is shown for the delay. Section 11 requires the committee to conduct an inquiry and submit a report within 90 days of receiving the complaint. The ICC has the power to recommend actions, which may include suspension or dismissal of the harasser, based on the findings of the inquiry. Section 13 and Section 19 oblige employers to implement the committee's recommendations, ensuring that there are repercussions for the guilty. Also, the law is not limited to protecting women employees. It applies to women across all forms of employment, whether permanent, contractual, or even interns. Now, let's discuss the #MeToo movement. The global movement empowered survivors of sexual harassment and assault to come forward and share their experiences, sparking conversations across industries and countries, including India. It opened the floodgates for women in India to finally feel comfortable enough to report instances of workplace sexual harassment without fear of retaliation. The movement has led to high-profile cases in India, shedding light on how widespread the issue is and pushing organizations to take more robust measures to prevent workplace harassment. The #MeToo movement also highlighted the importance of creating a supportive environment where victims feel safe reporting incidents. It's crucial to remember that the law doesn't just exist on paper. Its strength lies in its implementation, and #MeToo pushed both companies and individuals to start holding each other accountable. If you, or someone you know, are a victim of workplace sexual harassment, here's how you can proceed. First thing first, document everything. Keep a detailed record of all incidents, including dates, times, and any communication involved. Secondly, report to the ICC. As mentioned earlier, you can file a written complaint with your company's internal complaints committee. Third, External complaints. If your workplace does not have an ICC or you are unsatisfied with their action, you can approach the LCC formed by the district officer as per the POSH Act. Lastly, legal recourse. Besides the POSH Act, you can also file a criminal case under various sections of the IPC, such as Section 354A deals with sexual harassment and prescribes penalties ranging from a fine to imprisonment for up to 3 years. Section 509 addresses actions intended to insult the modesty of a woman, including verbal and non-verbal gestures, and can result in imprisonment for up to 1 year. These additional legal provisions empower women to seek justice beyond the workplace if necessary. Employers have several obligations under the POSH Act. Display an anti-sexual harassment policy in a visible place in the workplace. Organize awareness and training sessions for employees and ICC members. Assist employees who wish to file a criminal complaint. Protect the complainant from any retaliation or adverse action for filing the complaint. In conclusion, workplace sexual harassment is a serious issue that can no longer be ignored. With the laws in place, such as the POSH Act, and the #MeToo movement bringing the issue to the forefront, we are making progress. But it's important for every individual to know their rights and for every organization to ensure a safe working environment. That's all for today's episode. I hope you found this information valuable. If you have any questions or topics you'd like us to cover, feel free to leave them in the comments below. And remember, you don't have to face harassment alone. There is help available, and the law is on your side. Don't forget to like this video, share it with someone who might find it helpful, and subscribe to Law Logical for your weekly dose of law simplified.